All right. Welcome everyone to the IAPP web conference. Happy new privacy year. Odia Kagan on what to expect in 2023 data privacy, sponsored today by Catch. My name is Marjorie Boyer, and I am a speaker and programming coordinator here at the IAPP. A copy of the slides for today's conference will be available on your IAPP account in 48 hours. I'll be your host for today's program. We'll be getting started with the presentation in just a minute, but before we do, just a few program details. So participating in today's web conference will automatically provide IAPP certified privacy professionals for the named registrants with 1 CPE credit. Please feel free to post any questions you have for the panelists in the Q&A area at the bottom of the screen. Now onto our program, and I would like to introduce today's panelists. Firstly, I'd like to introduce you to Jonathan Joseph, Chief Solutions and Marketing Officer at Catch. Welcome. And I would also like to introduce Odia Kagan, Chair of GDPR Compliance and International Privacy at Fox Rothschild. It's a pleasure to have you both here, and we're looking forward to this conversation. And with that, I will hand it over to our panelists.
Thanks, Marjorie. Hey, Odia.
Hello.
I don't know what the, thanks for joining us. I don't know what the statute of limitations is on when we can, how long we can say Happy New Year, but I think we're cool saying it into January.
Yeah, and it's like a whole like privacy week thing. So like Happy Privacy Week, you know, we can
Happy
say
Privacy
that.
Week, Happy Privacy Year. Absolutely. Hey, I appreciate you joining us. I always enjoy reading your insights on LinkedIn and you know the international kind of perspective that you bring. So we've got a pretty ambitious agenda here. You know, we're rolling through the top 10 privacy trends for 2023. Here it is on the screen here. We're going to get into a lot of detail here. We're going to get into some of the relevant casework and some of the things to think about and practical advice. Odia, why don't we get started? I mean, the first one on the list here, sensitive and personal data, starting with biometrics. What's happening there?
So I think in this year, in 2023, we're going to see a lot of focus on sensitive information. And then the question is, okay, well, what is sensitive information? So the first thing is the new privacy laws define sensitive data, sensitive information, pretty much in the same way that GDPR defines special category data, plus a few more. So it's a pretty broad definition. What have we, and we've already seen it. So let's break it down. First of all, biometrics, right? Biometrics, we've already seen a lot of developments on. First of all, we've already seen a lot of enforcement. We've seen enforcement in BIPA, the Illinois Biometric Information Privacy Act. We've seen both a change in volume. So we've seen a lot more enforcement actions than we've seen in the past. And we've also seen a change in the nature of the nature or the scope of the enforcement, meaning instead of just seeing, you know, the time entry clocks or, you know, attendance, employee focused, we've seen other things. First of all, even in the employee context, we've now seen a palm print lawsuit. We've also seen other things that are not just employee specific. We've seen voice recognition, voice prints. We've seen it in the restaurant context. We've seen a smart CCTV and AI and facial recognition in public venues, in retail. We've seen facial recognition off of videos and selfies. So there is, and so that's, we've seen that. And the other is we've also seen the BIPA cases focusing not only where we've had traditionally cases on, hey, you don't have a private, you don't have a disclosure, you don't have consent, you don't have a retention policy, you have nothing for BIPA, hey, we're suing you. Now we're also seeing things like you do have a notice, but the notice isn't, you know, specific enough. You do have a retention policy or a deletion policy, but it's not compliant. So we've seen like things moving into a more granular level, which is interesting. And we'll talk about more when we talk about the transparency. But so that's kind of one thing that we've seen. Really important in this context is one landmark decision that we saw in the context of BIPA, where there was a $248 million judgment, which basically the court in Illinois, and we're still waiting on the Illinois Supreme Court for a conclusive solution on this, resolution on this, but basically this was a jury case. The jury deliberated for like 45 minutes, and after 45 minutes said there are like 54,000 violations times the statutory damages, and they in reaching that number. And that's really important to note, because all of these, like the BIPA cases, but even the pixel and cookie cases that we're going to talk about, when you're starting to count the violations per click or per scan, those things really add up. So that's really important. The other piece that we want to focus on with respect to biometrics is that there is a lot of legislative action in the context of biometrics. So we're going to talk about the comprehensive privacy laws that are popping up this year, but we've had, and Tatiana Rice from the Future of Privacy Forum follows these developments. So, follow her to see the developments, but we've seen, I think, like 5 or 6 or maybe even 10 biometrics bills in states like in New York. There are a few separate ones, Massachusetts, a few, Mississippi, Arizona, Hawaii, Tennessee. So we've seen, I think, Connecticut, and even an amendment of BIPA in Illinois. So we were seeing a lot of this sort of BIPA is coming to in Maryland as well, right? So BIPA is coming to a state near you. And so that is obviously going to increase the significance of this, as well as the likelihood of enforcement. So that's in the context of biometrics. Now, sensitive data obviously is broader than biometrics, and we're also seeing action with respect to the other kind of, let's say, prominent members of the sensitive data family. First, I'm going to talk about location, right? Location, enforcement. So the FTC has been vocal about location data. There's an FTC blog where the FTC lays out its thoughts on location and how location can be sensitive. Precise geolocation has been deemed sensitive by the FTC since it's the seminal paper from 2012 about privacy, and as requiring consent for processing. And the precise geolocation is also sensitive in some, but not all, of the new state privacy laws, triggering a need for an opt-in. We've also seen cases in enforcement, right? There was a case where there was a member of clergy who was outed because of a use of the location and inferences made from the location. And of course, there is the Kohava case with the FTC, where the definition of what is a sensitive location is being investigated. And of course, this is an interesting development because I think it's sort of like, I don't know if it's an intended or an unintended or consequence or benefit or something of the Dobbs case, because the Dobbs case kind of raised awareness and raised awareness in individuals and consumers with respect to what is sensitive, what are the consequences of use of information. And suddenly it's like, wait, the reproductive health and like geofencing and, my presence near a clinic or like Planned Parenthood or whatever. And Google and even some of the brokers have said that they're going to delete that information. Okay, so that's nice. But now you're like, well, if the reproductive thing can have consequences, then why not just like any health information? And maybe, I'm going to, another clinic. And so, or maybe, my browsing activities. And so there is a lot more awareness now with respect to inferences and what can happen with respect to sensitive information.
And how do you even come up with a list of what those sensitive locations are? I know like some industry bodies like the NAI have tried to do things like that, but it seemed, I don't know how you would do that. This is sensitive and this isn't when it comes to location.
So that is, some of it is going to be discussed in the Kojava case, right? As to basically what they were saying is that they are sort of arguing with the concept of what is sensitive location. I see myself frozen. Are you guys seeing me frozen too?
It's freezing a little, but we can hear you fine.
Yeah, I'm hoping, I don't know why the internet doesn't like me today, but hopefully it resolves quickly. And if not, I like this action shot here. That's cool. So at least it caught me in a good position here. So basically Kojava, the data broker, is debating what is sensitive location. And basically saying, okay, well, hey, FTC, you're not really telling me, you're not being specific. I debate this concept of sensitive location. And so that's going to get hashed out. But we do have a couple of things. We do know what sensitive information is. We have historic enforcement under GDPR on special category data. And we also have inferences derived therefrom in CPRA as a specific category of personal information. And we have a California Attorney General opinion talking about inferences being personal information. And therefore, so those of us that are lawyers, sit back and hear this, because I'm going to use a theorem, right? If inferences is personal information and sensitive information requires an opt-in, then inferences from sensitive information can require an opt-in or an opt-out in California, et cetera. So that's really significant. And we've seen some moves on this. For example, Facebook changed some of the advertising categories for targeted advertising that it has, which had already been changed. But there are some categories that are not sensitive by themselves, but from which you could infer that you belong to a sensitive category. And they have pulled back on some of them and said, okay, we're not going to use those anymore. So we've seen some movement on this, and we're probably going to see more as enforcement increases. And of course, as enforcement starts under CPRA on the actual CPRAE things, which is going to happen in the second half of the year. But the other thing that we can, sorry,
you had the NOIB decision today, right? Which was basically, obviously, location.
So the NOIB decision today, I think, said phone data is personal data, which I think hopefully most of us already knew. But, it's not like I don't see, and I'm sure that you see, privacy notices online that talk about non-personal information, and the non-personal information is IP address. So I think that now reinforces the fact that location information is personal information. Precise location information is sensitive personal information in a lot of the views of a lot of the regulators. And then the final thing is health information, right? Health information is sensitive information. Health information obviously is front and center for Dobbs. And here we're starting to see also in addition to enforcement, right? And OCR's talked about it. FTC has talked about it. And now we're also seeing bills. Washington State has the My Health, My Data bill that was submitted a few days ago, uses the GDPR consent. We're going to see that as a trend, by the way. Now, a lot of US bills are using GDPR Article 7 consent as the definition: freely given, informed, voluntary, specific, unambiguous, right? And when it requires disclosure and it requires consent for collecting health information, you need to only use it as strictly necessary, and you get rights with respect to it. So that's, I think sensitive, to summarize here, sensitive data is a broad category. Sensitive data is being more enforced, and sensitive data is going to be even further enforced as we see additional legislation going into force that handles this information.
So Odia, what happens with the intersection with laws like HIPAA and the state privacy laws in the US, at least? At some point, does HIPAA need to be updated? Do you take care of it in the state privacy laws? What's your prediction for what might happen there?
So that I think a couple of issues here. So one, what happens now, and then sort of prospectively, should HIPAA be updated? I mean, I think, this is sort of, HIPAA is an older law, and I think when legislated, it wasn't like privacy wasn't at the forefront of the purpose that it was supposed to handle. And we do see differences in that there are newer laws that are more protective of privacy. Obviously, this is going to be something that needs to be handled carefully because there's a lot of the market that's like reliant on it. And so that's an interesting issue. But what we are seeing is this. First of all, there is a lot. What is the interplay? The interplay is this. Some laws carve out application to covered entities, regardless of the data they process. Other laws, and the newer laws, carve out the data, meaning it doesn't apply to PHI or something that you treat as PHI. But in that case, and this is important because we've seen it, and we'll talk about the pixel cases, but even if you are a covered entity, and sometimes you're a hybrid entity, et cetera, but even if you are, you process non-PHI, especially in the online context. And so then the exception wouldn't apply. And then you need to be compliant with the state laws.
Gotcha. Thanks. To move to second to our list, children's privacy for me kind of hit the forefront with Epic Games recently. What are some of the things to look out for there in 23?
So children's privacy also, we're seeing two things. We're seeing more enforcement, more significant enforcement in number value. Epic was $520 million. And also in significance. You needed to delete the data that was procured without permission and need to reconsent, or not because you didn't consent in the first place. So first of all, more enforcement, bigger enforcement, significant enforcement, but also a lot of legislation that is coming into play. So first of all, let's talk about the Epic Games and then the legislation. So the Epic Games, first of all, something that's important is it goes into something that the FTC has already spoken about, but this sort of puts it front and center, which is what is the trigger, what does directed at kids, which is the trigger for COPA, what does that mean? And how do you ascertain it? And it goes into an analysis. And by the way, I posted an analysis of this on LinkedIn. So those of you, everybody is invited to connect with me, but look there. Basically, there's a very specific examples that are listed on how do you know that you're directed at kids. And it is about language. It's the normal things that were listed in the rules, in the COPA rules, right? Like the nature and the graphics and the language of the product of the online presence itself, but also marketing, your marketing strategy, your internal communications, and with your marketing group. And we're gonna, this should hit home with the 8 to 14-year-olds. And the fact that if you are targeting teens, that has a COPA impact. And so that's really important. They also talk about default settings and talk about the fact that the default settings need to be privacy friendly. And as I mentioned, also the significance being that you needed to delete the data and can't use it. The other thing that we're seeing, because we're talking about directed at children, we are seeing additional bills. One of them is actually already, passed. So it's not in effect yet, but the California Age Appropriate Design Code, which is a sort of, I don't know if copying or basically very formulated after, very closely following the UK Age Appropriate Design Code, which is already in effect. California is passed, but not yet in effect. Those are children's laws that, number one, apply to under 18s, not under 13s. And we saw a couple of bills that are also talking about 18 and the proposed COPA amendment, which also talks about 18. That's a very big game changer, first of all. The second game changer is it's not directed at children. it is likely to be accessed by a child. Now, those of you that have children, and I do, I know very well that likely to be accessed by a child is a very broad definition. And there are a lot of requirements in there that go further than COPA. For example, and actually sort of track some of the developments in the new meta cases from the Data Protection Commission Ireland, which we're going to talk about in a second. But things like you can't conditioning the child's participation in a game or the offering of a prize or another activity on disclosing more personal information than reasonably necessary to participate. That we've seen in some of the bills. The new West Virginia bill says that. The new Virginia bill says that knowingly process the information of children for targeted advertising or sale or profiling is prohibited. So it really changes it really changes things from COPA, which is a very traditional notice and consent law, to something beyond that, which actually says, okay, well, you can't do that in the first place. You need to kind of do data minimization. You need to, you cannot use because children, by the way, this is very similar to our discussion on sensitive information, because children are a sensitive category, right? Children are a sensitive population, and therefore, you need to treat them differently. So that means that you cannot use information you cannot use their information in ways that may be damaging, right? So like, stay tuned. So first of all, the takeaway here is this. COPA is here. COPA is getting enforced. It is getting more enforced. I remember like 6 years ago, I talked to a friend who's like, who cares about COPA? Well, that did not age well. Okay, that statement did not age well. Yes, we care about COPA. COPA, there were proposals for federal amendments of the children's privacy laws. COSA, the Kids Online Safety Act, I don't think was progressing, but maybe COPA will get amended. But we're seeing states coming up with age-appropriate design codes. California already, we've seen, I think New Jersey has a copycat law. A UK is already in effect, as with which is basically an application of GDPR. It's not its own like legislative. It's basically like, hey, to comply with GDPR with respect to kids, you need to do this. And so I think the kids' information is something that we're going to see a lot more enforcement and a lot more legislation. So it's definitely something to watch.
Gotcha. And by the way, Odia, when your screen freezes, it freezes somehow in flattering positions. So don't worry about that at all. So thirdly on this then, and kind of maybe riffing off Epic Games, consent and dark patterns. What's kind of some of what's happening there? You mentioned the pixel litigation and wiretapping.
Oh, so yeah, so the pixel litigation actually sort of ties into both the consent piece and the transparency piece that I want to talk about. So, so what basically we've seen. So let's talk about the health information first, but the pixel is also not health information generally. Basically, there is a bunch of litigation right now that talks about whether or not the use of metapixel and other pixels, tracking pixels, are whether or not that is without sufficient disclosure and consent, whether or not that is going to be an issue, whether or not that is a violation of, like, fill in the blank, right? Unfair, deceptive acts or practices, etc. And so we have a bunch of litigation on it. The key litigation is with respect to health networks, healthcare providers. Basically, what's happening is that the pixel is placed in such a location such that health information is shared with Facebook. And that is basically, there's been one case that was already settled in Massachusetts in a similar situation, which was like $18 million settlement. And there is a bunch of pending cases. Basically, the idea is that if you are sharing, you are putting Pixel, if you're putting Pixel in your website, and that shares, right, what doctor's appointments are you scheduling for? What medication are you interested in? Things like that, that is a sensitive inference, right? And then there are other cases where the pixel is being placed in other cases, not health, but like, hey, my information is being shared. That has significance. I didn't agree to this. Why is this happening? So this is really an important, I think this puts a spotlight on two things. The importance of transparency, the importance of the customer expectations, and the importance of choice/consent. And here it's sort of like a TBD because this hasn't been fleshed out in legislation, right? Does this mean that I need to opt in to this sharing? By the way, under certain state laws, if it's a sensitive inferences, Colorado, yes, right, already. But even if, and then, right, or is it enough that I have an opt-out? But what's obvious, because these are all sort of early stage and pending litigation, what's obvious is that there are a lot of cases where there is sharing of information, sharing of inferences, from which there could be real life consequences to the individual, and the individual had no idea. And that is no longer acceptable. These cases sometimes are being filed under unfair or deceptive acts or practices, UDAP laws. The interesting / cool / depressing, I don't know, depends where you are on this, is that all states, or maybe I think all, but you guys can Google this and find out. I think most states, if not all states, have UDAP laws. And the FTC is, obviously in charge of the biggest, like federal UDAP law, right? Section 5 of the FTC Act. So if those types of things, these sort of sharing of information without permission is a UDAP violation, then you don't need a federal privacy law or a new state privacy law to address that type of behavior because, hey, we're already here. It's a different interpretation of an existing law, and we already have a tool. So we'll see how they shake out. But in either way, that practice needs to be addressed.
Yeah, like just looking at some of the state laws and this kind of, I would say, super friendly consumer language, just like some examples, there's things like, hey, easy to read, to your point about transparency and what does that mean exactly? How do you find that? Easy to read, symmetry and choice. What else? Do not impose unequal weight on one available choice or another. Like these are don't add unnecessary burden or friction. Simple. And when they talk about the opt-out signal, there's some very consumer-friendly language. And so, like one of the ways we've been thinking about it at Catch is the consumer has emerged as a super important motivator here, and maybe in a way a tiebreaker as you're thinking about how to go. With state-by-state compliance, if you're doing the right thing by the consumer, you might be okay. Anything else, Odia, we're going a little out of order here, but we're talking about transparency. Anything else there? And specifically, like for me, purpose specification. Like I've just always hated the cookie banners and hey, this Google cookie is doing X, Y, Z. Do you say yes or no? How am I supposed to really answer that as a consumer? I want to know what the cookie does. Is it analytics? Is it advertising? So that I can actually have some educated consent to that. What's your perspective on, purpose specification, transparency, but also how do you enforce that purpose across your systems? Is that something anticipated by the laws or something you should just do?
I think both. I think here's the deal. Like when I posted the post for this webinar, I basically had a privacy Beyonce statement, right? If you collect it, then you should have put a privacy notice on it. I think that is, I think that transparency is a top priority, in my opinion, for regulators. We've seen it. The one thing, and we can say a lot of things, and I will now in the context of purpose specification, but a lot of things have been said about the DPC Ireland cases and the meta cases. But the one thing, because there was a lot of stuff, there's disagreement and NOIB and the EDPB. But the one thing that everybody agrees on, DPC and NOIB and EDPB and everybody, is that there was a transparency problem, and that the transparency provided did not meet with the higher bar that we are expecting, and that high bar is what we are expecting. And there are statements from Data Protection Commission, from the commissioner in the decision, that basically says very specifically, one, you can't use, and this was also Keneal, I think, had a decision on this, that you can't use may. May is misleading. If you are doing it, it's not may. We may, I mean, I can tell you yesterday I was marking up privacy notice and I deleted may like 5 times and wrote, no, it's not may, we're sharing it with our hosting provider. Like it's happening. So this kind of like, I'm actually reading a book about this, and it says like avoid, the fog and, face the reality, right? It's harder. It may be, depending on, it's harder, it's more work. It's, sometimes you got to go back to your stakeholders. You got to make hard, tough decisions. I don't know, but like, you can't hide behind the man. You can't give your consumers homework to, figure out your privacy notice, right? You can't. And this is very specific also in the DPC decision. And it's also very specific in the CPRA regs and in the Colorado CPA rules. You need to have process specific disclosures. When you read something, you need to understand, when I open an account, this is what you're collecting from me. This is what you're using it for. This is how long you're going to use it for. These are my choices about it, right? You can't have a list of, here are 20 things that we may use your information. We may collect from you. Here are 20 things that we may use that for, and just figure out do the match up. I've said before, like I'm a big fan of Duolingo, and they have the list of the language words and then the foreign language words, and then you need to match them yourselves. And no. You've got to match them for the user. So transparency, the big deal. We see it in the CPRA regs. They are very specific about it. It needs to be consumer friendly. You need to have the information available in order for you to make the choices. FTC has said that right and left and up and down, right? And then the purpose specification is related, but different. Purpose specification obviously is part of transparency. You've got to tell people what you're using the information for, otherwise there is no way for them to know. But you also need to only use the information for the purpose that you said, or a compatible purpose. And and that's kind of also related to the meta cases, because they were talking about necessity and whether or not the extra uses were necessary or not. But basically what it means is that you can't just, and there is a bunch of examples in the California regs too. Like if you're collecting somebody's, they actually use the Twitter example, right? If you're using somebody's phone number for, multi-factor authentication, you can't also use them for targeted advertising without, number one, telling people about it, but also, and this is the meta case, but also California and Colorado, getting permission to do that, because you can't do it. And in those situations, and that one I flagged as a, the first one was Taylor Swift, privacy Taylor Swift, right? Like, look what you made me do, because the New York bill, which is the Privacy Act, I think, basically used the DPC Ireland language on, targeted advertising is not necessary for the purpose. You need to get a separate consent for it. And there's a New York bill from yesterday, which says something similar, which says a similar thing, which is, or related thing, which is you can't just include stuff in terms of use and have an I accept at the end and have that be agreement, right? It needs to be granular. It needs to, and Colorado has a very specific list, very helpful. I think it's sort of better than the ADPB guidance on it, that basically says, here are the criteria that you can use to analyze whether or not your secondary use is compatible. And if it's not compatible, go back to, collect, 200 and go and get consent, right? And so that's very important because it changes the way that businesses are looking at things from just, and the FTC, by the way, has said that too, right? The bottom, the sort of lowest common denominator is, number one, you can't just stick stuff in section 47 of something and call it and say it's consent, right? Number two, you need to tell people what's going on, and you need to tell them in a way that they understand, right? And number three is you may need, and I say may because the laws differ, but you may need an opt-in or an opt-out or something for a secondary use. And that does vary by the law. And then the other thing that I want to add, because we didn't include it before, is that in this concept of consent, two more things about consent. Number one, consent under the new US laws, California, Colorado, and the others and even the bills we're seeing the New York bills, the Virginia, a bunch of new bills that came out, they all literally use the GDPR definition of consent: freely given, informed, specific, unambiguous. That's a big deal because those of you that have been following case law and enforcement on consent, that is a big deal on conditioning services and what that means. So that's number one. And as you said, also how, right? The dark patterns, which we'll talk about too. And the second thing is the stuff that you need. So this also, again, is sort of, it's like, when you walk when you're in the beach and you're like walking into the water and you like accidentally kick something and all the sand sort of, kicks up into the water, right? So now we're seeing consent and it kicks up other situations of consent. And we see a whole wave of wiretapping lawsuits in context that we've never seen wiretapping lawsuits. Wiretapping, like maybe this is not the sand. It's like somebody blew off all the dust from the wiretapping laws, right? And suddenly we have wiretapping in the context of session replay, and wiretapping in the context of keylogging, and wiretapping in the context of transcribing chats or transcribing Teams calls, or those of you that joined saw the new Zoom blurb when the session is recorded and telling you what's going on with the recording, right? So this is also something to pay attention to, because this seems like, oh yeah, we have a chat bot. And like I've seen this in conversations with clients, like, oh yeah, we have a chat bot and we transcribe it and we use it just for product improvements. Like, does anybody know about this? This is a contemporaneous recording, right? This is wiretapping. And again, right, we don't need fancy laws for this, because we have wiretapping laws, and hey, we dusted them off and now we're using them for, for things like that. So that's, I think, another thing that's important to know. It's
so interesting, right? Especially as we kind of think about AI and ChatGPT, of course, and all these kind of things that are coming for us. Yeah. The transcription that we're seeing on calls, like even the way that people do marketing, and here's the tone of that call, and here's the tone of this call. To plug that into wiretapping is fascinating. Odia, I feel like I'm on 60 Minutes or like Brian Gumbel or something interviewing here. I wanted to take a small break, come back to data minimization, but the small break is somebody asked what's on your reading list lately.
Oh, I have a thing on the privacy side, or just life?
I think she meant life, but we'll do both.
So I'm reading a bunch of books at the moment. I'm reading nonfiction. So fiction, I'm reading We the Living, the Ayn Rand book. It's pretty old, but it's really good. I'm reading a philosophy book, The Daily Stoic. I'm reading The 48 Rules of Power. I'm reading, and then I'm reading Seek and Hide, which is a privacy book. It's about the history of like the privacy, how privacy was a thing in the 1600s, and it's still a thing. So
thanks. Yeah, she did. Yeah, good. I appreciate that. She just came back and said, yeah, I want privacy ones as well. So data minimization, Odia, is like a fascinating one for me. We were just at the IAB conference, and it was a bunch of marketers and advertisers, folks in the media space, and obviously very unhappy with just the term surveillance capitalism, of course, right? And so there was a lot of discussion around that. Data minimization is fascinating for me because, like, how do you know what data you need in a context unless you've collected it all up front? And is it better to say data relevance? And it's like the industry needs to kind of collaborate on that, but I know the laws are, I guess, pretty clear on what data minimization is. How do you think about it? And I mean, in the context of collection and retention?
So I think that this is a very, very big mind shift. And I think the ship has sort of sailed on this because everybody is on board with data minimization, right? GDPR has already been there. The new privacy laws, right? California, Colorado, everybody else, they have a specific duty of data minimization. I mean, the new laws, the new New York Digital Fairness Act also says you cannot make any decisions that are in your interest over the interest of the individual, right? Going even a step further. But with respect to the data collection, right? We've seen GDPR in the new state laws. We've seen FTC in Cafe Press and Drizzly. And I'm going to say a couple of words about that, but we've also seen it in the comments. This is like looking at like trends and things that are incoming. In comments to the FTC notice of proposed rulemaking, there was a letter, I think from like 35 or 34 attorneys general in different US states, all of whom supported data minimization, which means that you already know what the AGs are thinking. You know what the FTC is thinking. It's already in the privacy laws. It's already in GDPR. Therefore, if it's already in Section 5 of the FTC Act and in the other UDAP laws, like you already, I mean, and you know, query, you know, whether it is or not, or where I have seen people, I've seen some commentary on this saying like, where did this come from? But the fact is, right, that this is what the regulators are saying, and they are seeing data minimization or the lack thereof as an unfair or deceptive act, right? So we've seen it in, so Cafe Press was a data minimization on the back end. It was don't retain for longer than necessary for the purpose. And that as it does, right, got revealed as part of a breach. And the breach, there was all sorts of information that should never have been there. And that was usually the reasoning before CPRA, GDPR, and the new state laws. You know, the reasoning that I would give clients on like, no, why do you retain the data? Why not? Well, because if you get breached, then you have a data breach duty, right? And now you also, so that's Cafe Press, right? But in Drizzly, you have one data minimization on the front end, which is don't collect more than necessary in the first place. Don't retain it for longer than necessary, but also important kind of drafting note for retention policies. You need to also provide the reason for why you're retaining. And that is sort of the FTC like dictating it. But I've been telling clients to do this for a while because basically you need a story. You need a reason. If the regulator comes and says, or if you have a breach and there's information there, you need to have a good reason to say, well, that's there because. And, right. You know, when we did this exercise, I've had, you know, there were situations like, oh, we retain indefinitely. Why? I don't know. Like it was cool because it's cool to retain.
It was a wild west of data, right? Like collect as much as you can, store it for as long as you can. I think people are coming to the realization that's not the way we do it anymore. It's funny to tie it back to the consumer as a motivator here. The Optus case in Australia, where they were collecting, you know, passport and license information, which made sense when you're doing some identity verification, but then to just store it and then it was subject to a data breach. Even my mom was saying, "Why did they do that?" She just didn't understand why they kept it for so long, and this is starting to hit the news. Let's see where we're at here. So I think we're at 6. We've got 15 minutes. Do you want to say something about the US state laws? I mean, obviously, maybe goes without saying, federal law, probably not going to happen. What's
I mean, I'm sad. I mean, I think that, you know, I don't know. I hope that what we are seeing in the federal front is we're seeing like tailwind. Like we're seeing that the importance of this is trickling upwards. We're seeing movement in Congress on bills on federal bills, maybe not comprehensive. And we're also, and the state law of what we are seeing is we're seeing a ton of activity in the states. And then the question is, right, the ton of activity in the states and the fact that maybe we're going to shake out on lowest common denominators on certain things may, kind of kick it up to Congress. We'll see. But the states, we've seen a lot of things. We've seen, I think, I have lost count, but I think we're like close to maybe 20 comprehensive data privacy bills, like 20 different states, 15 plus different states. But even more than that, we're seeing state bills on specific aspects of things. Like we said, right? Biometrics, children's information, employee information, AI, which we're going to talk about separately, AI in the context of employment and discrimination. So we're seeing health data, so we're seeing a lot of activity in the states. And I call it, what does that actually mean? So I call it Kaleidoscope 2023 because it's like, kaleidoscope, it keeps moving and then you get dizzy and you really need to try to focus in order to not go cross-eyed. But I think on the one hand, this is very difficult. And I think I understand that. And that's sort of the appeal of a privacy federal law for companies, because this is difficult because I've had, clients like, oh, but I have, California is an opt-out, but then Colorado is an opt-in, but precise geolocation, it's sensitive here, but it's not sensitive here. And it's very confusing to try to comply with 100% and the last mile of all of these. And so that is difficult. What's the solution to it? There is no good solution, right? You need to keep doing your best. But what you definitely should do is you definitely should have at least a baseline that covers most of everything. And then, and especially, giving emphasis to, the sensitive information and unique uses of information and things other than strictly necessary for the purpose. And we're going to see, but I think, we're seeing activity in states like New York, in states like in Massachusetts. So I think we're seeing a lot of activity and people need to kind of get ready for that.
Odia, the folks over at Forrester, or Enzo Iannapolo, who's a primary privacy analyst over there, refers to it as sustained compliance. We go back and forth with our clients on whether it's a state-by-state approach or national approach. And I think for us, the way we've solved it is you need the flexibility in your consent management platform to be able to have a state-by-state if you wanted to. There's a lot of good reasons to do that. And so that's where some people are going. Like for me, it was relatively new to understand you can't just adopt California as an example and think that's the strictest, because as you mentioned, Colorado in some instances is stricter. It requires opt-in rather than opt-out.
Yep.
So yeah, keep that flexibility in your technology, and to tie that to data types, as you kind of said, you need data discovery. So this idea that your data discovery is a survey and isn't automated, and importantly, isn't connected to your other privacy management software just seems like a no-go for this year. But hey, back across the pond, if you will, in Europe, they're obsessed with cross-border transfers. We were in IAPP in Brussels where you and I met, and that's all they talked about still. So what's going on?
What's going on? I think, right, it's the same issue. The same Schrems 2 decision is still in effect. Same problems. But I think here, what's new, right? So first of all, obviously, the executive order, the data privacy framework is new. And that got, kicked off to the European Commission. We have a draft adequacy decision. Because it's draft, nothing is in effect yet. But what it does mean is there's two things it means. Number one, if it goes as planned, which, the expectation is that it will, then at least it's going to, if nothing else, right, change some of the perception among the European regulators with respect to the problematic nature of the NSA ate my cookies, right? So all of the TIAs that talk about, you know, the NSA and the cookies and all of the things that are really beyond our control are maybe going to be looked at differently. What is something that but that is really something that we can, it's like, you know, I told you that I'm reading like the Stoic philosophy. And one thing that they're saying is that, you know, only worry about things that you can control, right? And the NSA and the cookies and the legislation on the federal side is something that none of us really can control. So what can we control? So one aspect of the adequacy decision and the package that was provided by the US is the principles, the data privacy framework principles. And the principles are the commercial side, right? What are the undertakings, the framework that companies need to do in protect the data coming from the EU in order to comply. And those should be the point of focus, because that's really something that we can do something about, because that is how we protect the data. Interesting. So companies that are not certified, you know, can look into becoming certified in order to be ready by the time the adequacy decision goes through. I mean, the certification mechanism's open, and it's been open because it's the same certification mechanism from the Privacy Shield days, and it's going to take time. The other thing I'm going to say is that even if you are certified, you should look into it. Why? Because, and the quote that I use for it, you guys some of you might have heard me say this already. It's like when you read, let's say when you read a book, right, when you're 10, like you read Animal Farm when you were 10, right? And you read it again when you're 25, it's not the same book. So when you look at the data privacy framework principles from 5 years ago and today, they are almost the same. They were almost not amended. The markup is minimal, and that's probably something that both the EDPB and NOIB are going to at least complain about, and we'll see what level of effectiveness, because they're pretty much the same. And that, from the European perspective, is maybe lacking because GDPR happened in the interim, and the things that were essentially equivalent with the Data Protection Directive may not be essentially equivalent with GDPR. But from our perspective, and from your perspective as a company trying to comply, those rules from 4 years ago or 5 years ago are not the same. Why? Because of everything we said in the previous 52 minutes, which is the FTC is looking at these principles. We already know what the FTC and the attorneys general and the class action lawsuits are thinking about these principles. So while 5 years ago we were looking at transparency, is not the same transparency. When we were looking 5 years ago at data minimization, not the same data minimization. When we're looking at consent and consumer expectations, not the same consent and not the same consumer expectations. And so those and the final thing is, not only are they looking at it differently, and everybody's looking at it differently, they are going to enforce it differently. And the reason they're going to enforce it differently is because one of the key complaints of the Europeans, both in the Privacy Shield reviews and in the lead up to Schrems 2, et cetera, is that the FTC was not enforcing this enough. There were a lot of cases of, hey, I said I was Privacy Shield certified, but actually, no, I lied, I wasn't. There were a lot of those, but there weren't any like substantive compliance problems. And by the way, Cafe Press did have a substantive compliance issue with the Privacy Shield, right? And so we're going to see, and when there was a letter attached to the adequacy package by the FTC saying, hey, we're going to enforce, we're going to have random checks, we're going to listen to your competitors complaining about you and investigate. And so this is not a rubber stamp. So I think for those reasons, one, it is not the same thing that we saw 5 years ago, and two, it is going to be actually more actively enforced. Those are reasons why companies should prioritize and, you know, invest in the certification.
Thanks, Odia. By the way, I learn something every time we chat. I appreciate it. We're going to have to go lightning round on 8, 9, and 10 here.
So I think so employee privacy, one, employees are people in California already under CPRA. They have rights under CPRA. They have DSARs, they have access rights, they have deletion rights, and they have disclosure, which they already had before. So that is something to remember. The other is there are laws that are handling bits of it. BIPA in the context of employment, discrimination in the context of automated employment decision technology. We have a bill, we have a law in New York, we have a bill in New Jersey, we have other bills that are already in effect on specific, like, AI in recruitment. We have statements by the EEO on this, right? On you cannot discriminate. Your prohibition on discriminating via AI is the same prohibition as discriminating via anything else. We're just going to look at it at the AI, right? So employees, and also really important is, again, in the context of the consumer expectation and the context of secondary uses, especially sharing of information and sale. These are things that even for California, I did not believe were in scope, even for CCPA. I didn't think that I originally didn't even think that if you're selling employee data, that's in the carve out, because that's a sale of the employee data, is not a use of the data in the context of the employment. So that is something to think about on the scope when you're having these kind of unexpected, invasive uses of employee information, especially sensitive information, location information, health information, things, gender, ethnicity, things like that. I would watch for that.
Does the CCPA employee provision, does that extend to job applicants, or are job applicants treated like consumers would be?
So I think, so now that, now everybody's now under CPRA, now everybody is in scope, right? Because they weren't before. And I think before it was carved out for both, but even though the applicants did and do still deserve their own disclosure, but now they're all in for California. And we saw a law today in New York with respect to certain bits relating to employment. So I think it's something to watch for. And by the way, ADPPA carved out employee from the preemption. So all of those employee laws that will pop up are not expected to get preempted by the federal law. So that's also something to know.
Yeah, the other states don't have it, right? Outside of California.
Not comprehensive. But there are specific bits of it, like the automated decision-making stuff. And then AI. So AI, we talked about kind of tangentially, right? We're going to see more AI because we see more AI and there's a lot more uses. But regulators are taking note of this. We have legislative initiatives in the US on the federal and the state side. We have the AI Act incoming in Europe, and we have regulators taking note. The FTC has spoken about it. There is in France, there is a new task force. The Netherlands is also, they have more authority on regulating AI, and they're going to investigate it. The Norwegian authority just published a paper on transparency in AI. And then other applications, right? Like, let's talk about second training, using personal information for training data as a secondary use of the information. Let's talk about, consumer rights in AI, right? So those are not novel. Those are sort of, we don't need new laws because AI is only a more sophisticated type of processing, and we are expecting regs on it under California. So we're going to get more clarity on AI and profiling. And then finally, risk assessments. They're required under Colorado, very detailed. Sort of the regs are in flux a little bit, but there's still a really good baseline for what to do with your DPIA. If you're not sure about using Colorado as your baseline, you can use GDPR as your baseline. California works, there's a meeting by the CPPA next week that's going to talk about the new tranche of regs that's going to include the risk assessments, but they're all required and we all kind of know what to do. So I think not doing them because you want to have the perfect format when Colorado shakes out, but in the meantime, you're having risky processing and you didn't do a DPIA. No, do the DPIA and then add the 3 little things that Colorado is going to add to what you've already done, but don't not do it, because in that situation, like, enemy is perfect is the enemy of the good in that context.
Thanks, Odia. Hey, as a closing comment, I'm going to thank you, and thank you everybody for joining us. We're going to send around a little summary of all of this. So we'll kind of email that out. Here's a CPE credit. Marjorie just posted that. Odia, as a closing comment, this idea that the consumer is a new motivator for this and, their data dignity is important. What's going on in Hawaii? Why is that important?
So Hawaii has a bill to amend the Constitution to make the right to data, the right to your data, a property right. And that's super interesting because that's a really long discussion. But the fact that it is, property is something that's, very ingrained in sort of the American culture. And so ingraining data as a right to property and raising it to the level of a constitutional protection is something that should that tells us, everything we need to know about the importance of data privacy in 2023.
It's huge. Thanks, Odia. What a nice closing comment. Thank you, everybody. And special thanks to the IAPP. Thanks, Marjorie.
Yeah, thank you guys so much to Jonathan and Odia for that great discussion. We also want to give a great big thank you to Catch for sponsoring today's program so that it was free to the audience. And lastly, I do want to encourage you to click the survey link that was just put in the chat and briefly give us your feedback on today's program. It really helps us to improve our web conference programming, so we certainly appreciate it. So that wraps up the program here today. Thank you all so much for joining us, and we hope to see you in another IAPP web conference soon.
Thanks, everybody. Thanks, Odia.